Until the judge wants to so you want to do that before you hear me on open cognizance, because obviously it's a complaint.
I think well, some of them. My wife wants to think went to the area, but yeah.
No, I was.
Something happens, right? Actually, right home. So it was in an hour. I was going to get him. I don't mind driving. I just stop and drive. I wouldn't mind now if you drive. It's fine. You know, that's how we look out there. When things on or whatever you get. I better look that bad because I would go. You
got people sit over here as well, okay? I don't want anybody standing, so try to make some room for everybody, please. You have to squeeze in. I don't want anyone standing. Over here as well. That's it.
Yeah. All right. Court's in session, you may be seated. Good afternoon, Your Honor. In the matter of Aidan Kearney. Mr. Kearney is before the court on docket 25 CR 225, being charged with one count of witness, intimidation of a witness or a police court official on March 5th, 2025 in the town of Canton. The defendant has filed a motion to dismiss. Commonwealth filed a motion to revoke the defendant's bail, and there is an email for you.
Just give me one moment to look at the email. And just to be clear for the record, there was a video that both counsel submitted. I've marked it as Exhibit 1. It's in the court's file. I viewed that prior to coming out.
Thank you, Your Honor. No objection to that.
Thank you.
Timothy Bradle on behalf of Mr. Kearney. Good afternoon, Your Honor.
Good afternoon, Attorney Bradle.
Good afternoon, Your Honor. I'm Robert Cosgrove, Special Assistant District Attorney for the Commonwealth.
Good afternoon.
That's relative to the bail revocation issue, Your Honor.
Okay. Stu, do you want to hear the motion to dismiss prior?
In light of the Commonwealth's position, I would certainly ask for that, Your Honor. Thank you.
All right, I'll hear you.
Thank you very much, Your Honor. Your Honor, the Stoughton Court, I just want to start with this court. The Stoughton Court has a interesting relationship with the witness intimidation statute and me and Mr. Kearney and some other clients I've had. There's been about 5 or 6 cases that have come through here where this exact type of conduct at issue in this case has been not acted upon by the court. Judge Walsh in this court, in a case called Commonwealth versus Richard Schiffer, same kind of thing. The Canton police did a 37-page investigation of Mr. Schiffer leaving rubber ducks around Canton with political messages on them relative to another prosecution that you're probably aware of, the Karen Reed murder case. And the Judge Walsh dismissed it at arraignment for violating the First Amendment. Assistant Clerk James Flanagan in this court, I represented four women that were accused of the similar things, sending out messages, commenting on the case directly to witnesses, leaving ducks around Canton. All 4 of them were not acted upon. There was another instance of what's called the Canton Nine, Your Honor. People that were demonstrating in the middle of Canton. There were 9 people were charged with witness intimidation and other related charges, all dismissed. So the Commonwealth just doesn't get it, Your Honor. We need a seminar on the First Amendment. And here we go again. We have Mr. Kearney in this case, Your Honor, is exactly where he's absolutely entitled to be. There's no stay-away orders in place. There's no restraining orders. There's nothing that prohibits Mr. Kearney from going down that street. He went to Jeff McCarthy's for a meal, and he walked by the complainant Albert's Pizza Place in Canton. He looked inside. He saw a camera inside and looked at it and looked in there and spoke to no one, to a glass window at 9:30, 10:30 at night, 2 occasions before and after. So he had every right to say what he did. The only involvement that the court needs to be concerned about would be if he uttered threats or fighting words. That's already been roundly established in my 14-page memorandum, Your Honor. I'm not going to belabor it. I know you've read it. I appreciate you having that. And the cases are all there, absolutely spot on point, Your Honor. All these issues have been covered. There's no threats here. There's no fighting words. There's nothing that is criminally actionable that happened whatsoever. Because the Commonwealth doesn't like it, they want to use it as probably their 10th or 11th, what I hope will be their failed excuse to try to go after Mr. Kearney. Not because he's a danger to anyone, not because he's doing anything criminal, but to silence his speech. That's what this is about, and that's why I've been so happy to always be coming to the Stoughton Court on these cases, because the Stoughton Court gets it. The Stoughton Court looks at these cases and says, this is not a crime. Stoughton Court has, with an unblemished record, Your Honor, upheld the First Amendment, and I hope that in this case, which is just as weak, if not weaker, than all the other things they're trying to say are felonious activity, I hope the court will address it appropriately, and I know the court will. So in terms of whether the court ought to, whether the Commonwealth, rather, ought to be permitted to bring this forward, there's absolutely no basis. Everything that Mr. Kearney said is not actionable. There's no threat. There's no fighting words. The only reason, Your Honor, that this has been given life, Your Honor, is because of the complainant's illegal wiretapping. He had a camera inside the store that apparently picked up sound, and also, Your Honor, there was a camera in the top right outside on the street that picked up the sound of every person walking by. So there's no warning signs, there's no notice that someone is being intercepted under 272 Section 99, the wiretap statute. He's been committing a felony every time someone's voice gets picked up on the street, and there's no warnings about it whatsoever. So Mr. Kearney doesn't have to, when he's clowning around outside the store where he's absolutely allowed to be. And incidentally, Judge, the last time we were all together in Superior Court, Mr. Kearney agreed under Section 87 to a stay-away order on this situation. So that speaks well of his understanding that he's not going to risk any other problems or issues. So that's on the side, if I may, Your Honor, that this has been agreed to when the government brought the bail request that they told me they were going to be renewing here. We agreed to it. So I want the court to be aware of that as well. But in terms of this speech, Your Honor, the only reason that the complainant heard this speech is because he was illegally wiretapping Mr. Kearney. This never would have come to life. He never intended it to come to life. He didn't know it was going to come to life. And the next thing you know, he's being wiretapped by the complainant, who now wants to use his illegal behavior to try to get Mr. Kearney locked up. The whole thing is a complete absurdity, Your Honor. Mr. Kearney is talking for the benefit of his friends to a window on a almost empty street at 10:30 at night. There's no danger whatsoever. There's no basis to plug that conduct into the many elements of witness intimidation to try to concoct some bizarre alchemy, some felonious charge that would somehow get past the First Amendment for all the reasons that I stated in my motion, Your Honor. So that's what I have for the court. I appreciate you reading my motion, and I'm asking for about the 10th or 11th time that the court dismiss these charges. Thank you.
Thank you, Your Honor. Mr. Albert, as is his son, is a witness in the Karen Reed case. Mr. Kearney has been in the process of conducting a campaign against virtually every Commonwealth witness in the Karen Reed case, using his various media outlets. What I would like to do is briefly read the court some excerpts so I can put them on record from the police report of Lieutenant Tully. Some of it characterizes the video that Your Honor has already viewed, but it's also illuminative of the reaction of the Alberts upon viewing that video. After I do that, Your Honor, I will proceed to address the contentions that have just been raised by Mr. Bradle. Lieutenant Tully indicates that on March 5th, he spoke with Chris Albert, and he mentions that the Reed defense attorneys have alleged a massive conspiracy to frame Reed and have stated in written pleadings in an open court that Colin Albert, who is Chris Albert's son, is responsible for the death of John O'Keefe and that Chris Albert has aided in the conspiracy. Beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses, members of their family, and their friends. The author then publishes a blog on the website Turtle Boy Daily News. The website has a series of articles entitled Canton Cover-Up. He goes on to describe arresting Mr. Kearney on charges he was later indicted with. Those indictments are still pending in Norfolk Superior Court. Chris and Colin Albert are named victims in those open cases. Chris Albert forwarded to Lieutenant Tully 2 videos from March 4th of 2025. Subsequent to that, Your Honor, the District Attorney's Office merged those 2 videos, so the video that you saw shows the 2 of them playing simultaneously. They're 2 different cameras showing the same events. The sound has also been enhanced, but otherwise the videos are in no way changed. As described by Lieutenant Tully, the video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is a bar/restaurant located next to D&E Pizza at 614 Washington Street in Canton. The group is seen leaving McCarthy's that joins Kearney. Kearney stops in front of D&E and places his face next to the glass window. Interior camera catches him standing close to the glass, staring at the camera for approximately 25 seconds. Male with the group that exited joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. Audio is captured by an exterior camera. The sound of the occasional passing motor vehicle obscures the audio. Lieutenant Tully stated that he could discern the following statements made by Mr. Kearney. "Hi, Chris. What have you done?" "Murdered," then goes inaudible. "Misses you. Wishes he was alive today. He would be." "Why did you do that, Chris?" "Chris, why did you tell the jury that you got home?" "Why did you say you went upstairs and then waited 15 minutes? And Colin came home. Colin didn't make it home until at least 12:45. Chris, it was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands to herself, too." The statements made by Kearney and his conduct of standing outside D&E Pizza is similar to the conduct that was the basis for his prior indictments. Kearney directed his statements into a camera that he knew would at least be seen by Chris Albert, a named victim in the pending witness intimidation case and a witness in Commonwealth versus Reed. When Chris saw the video shortly after the incident, he became upset. He stated he is upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him or his son, which I would add, as he has done in the past. Subsequent to that, and as Mr. Bradel indicated, I brought this conduct to the attention of the Superior Court at a hearing on Mr. Bradel's motion to dismiss about 2 weeks ago. Lieutenant Tully received another video, and I want to add, with respect to the first one, that what brought this Chris Albert's attention was that on March 4th, he received a phone call from his son, Colin, who was working at a pizza restaurant that he owned. Colin learned that Kearney was having dinner at the restaurant next door. He was very unnerved and anxious about Kearney being next door while Colin was working. Chris, who was attending a Canton Select Board meeting, traveled to D&E following the meeting, and they closed the pizza restaurant at 9:30 and went home. He then received an alert on his cell phone from the camera system at D&E Pizza access the video recordings, which Your Honor has viewed. Chris was very upset about Kearney's statements into the video camera, especially given previous incidents where Kearney picketed outside the restaurant during business hours. He's also very concerned Kearney will continue to be outside the restaurant and will confront him, members of his family, or patrons in a similar manner Kearney has done in the past. And I think the second video that Your Honor saw was a later discovered video indicating that Mr. Kearney had been present earlier in the evening. Now, with respect to the motion to dismiss, if I can turn to that in this point. I don't have a quarrel generally with the proposition the First Amendment protects a wide range of free speech, and that the usual remedy for a victim of defamation is on the civil side of things, and not on the criminal side. But what the defendant ignores, and I believe Mr. Bradel ignores, is the courts from the U.S. Supreme Court on down have said, where the Commonwealth or the state has a compelling interest, it can craft an appropriate limited criminal sanction regulating speech in a reasonable fashion as to time, place, and manner. Now, there are a number of examples of that in our law, Your Honor. I'm sure Your Honor has probably had occasion to issue 209A orders. The typical feature of those orders is that the 209A recipient is to have no contact, direct or indirect, with the victim. And the cases have uniformly supported that when that contact is made, whether it's a phone call, we might otherwise say is freedom of speech, even if it's an innocuous subject matter, even if the defendant sends the recipient of the 209A order, the protected person in the 209A order, a bouquet of flowers, that is a violation that may be criminally punished. We also know that laws protecting courthouses and prohibiting disruptions outside of courthouses are also constitutional and legal. We also know that judges routinely impose conditions of probation, requiring no contact, stay away, not travel in a certain area. Those orders, too, Your Honor, arguably impinge on rights of free association and speech, yet all of those are constitutional and have been upheld. With respect to the victim witness intimidation statute, which is at issue here, the legislature has imposed a very limited restriction on speech. And the limitation comes in the form of two elements. One is the protected class is not the public generally. They are left to their civil remedy. But the protected class are witnesses in a criminal case. The second reasonable limitation, the second restriction, Your Honor, is that to prove witness intimidation, The Commonwealth must prove beyond a reasonable doubt the specific intent of the defendant's conduct was to intimidate the witness. Now, it seems to me, Your Honor, that one of two things has to be true. Either 209A orders, probation conditions, and laws against disrupting court proceedings are unconstitutional under the First Amendment, possibly other amendments as well, as is the witness intimidation statute. Or the witness intimidation statute constitutes a reasonable limitation by the legislature in service of a compelling state interest, which is the integrity of the criminal justice system. Mr. Kearney has effectively conducted a campaign against virtually every Commonwealth witness in this case. It has been unrelenting. I don't know if I am to go back to those witnesses, those victims, and say, well, you have a civil remedy, go over to civil court, file a lawsuit, hire an attorney if you can find one, retain him for $1,000 or $20,000 or $50,000, or maybe you can get a contingency fee. And then after depositions and motions and interrogatories and so forth, 3 or 4 years from now, you might recover a nice civil judgment. But in the meantime, every day you are going to be hammered and intimidated, and there is nothing the criminal justice system can do about it. Those seem to me, Your Honor, to be the alternatives. And based on that, Your Honor, I would ask you to deny the motion to dismiss.
I have a couple of answers.
Briefly.
Judge, page 5 of my brief, U.S. v. Alvarez, sets out the entire field of where the government can intrude on the First Amendment. There's no provision for reasonable restrictions on this or that. There's no opportunity for the Commonwealth of Massachusetts to try to criminalize civil tort law somehow.
I don't think that's what Attorney Cosgrove was saying. I think what he was saying is that it's a different class than the general public. And while I agree with your sentiments regarding Alvarez and the general public, what we're talking about is a more restricted class, specifically witnesses in a criminal proceeding or possible witnesses in a criminal proceeding, and in this case, a known witness in a criminal proceeding.
There's one other issue there, though, which is that there's no stay away order. It's not even a stay away order.
And that's
the determining factor.
well, that may be the determining factor at the end of the day with respect to a defense at trial, or perhaps whether or not his conduct was harassing as the statute anticipates. But the standard of proof that I need to apply here is whether or not there's probable cause that he's violated the statute. And the statute that reads that did mislead, intimidate, or harass another person who was a witness or potential witness.
Yes.
And
Can I address that point?
sure.
Thank you. I appreciate you letting me jump in there. Harassment is defined, and harassment is limited by O'Brien v. Borowski, true threats, fighting words. So manifestly, these videos have no threats, no fighting words.
So take the sound out of it. The video that I watched that you both submitted by agreement begins with him just staring directly in the camera. He's not passing by. He walks to the camera and then he walks back in the direction from whence he came. And he's staring at the camera for a prolonged period of time before another individual comes up and starts speaking to him, and that's when the words happen. And whether or not you have a Fifth Amendment claim for the witness at trial because of wiretapping or not, it's not what's before me. What's before me is whether or not there's probable cause to support the charge. And after considering your motion and the depths of research you've done on the First Amendment and considering the standard of proof that I need to apply here, which is probable cause, I'm going to deny the motion to dismiss.
Please note my objection. Thank you very much.
Your objection is certainly noted. Commonwealth, I hear you on your motion and any request for bail.
Thank you, Your Honor. With request to bail on this case, Your Honor.
Does Mr. Kearney be arraigned first?
He was arraigned. Right, you entered pleas of not guilty. He was arraigned. I mean, I would have stricken the arraignment had I allowed the motion to dismiss. That's why I wanted to address it first.
Thank you, I appreciate it.
With respect to the question of bail, Your Honor, I'm going to request that the court set bail in the amount of $5,000 cash on the instant case, and I'm going to ask the court to impose a stay-away order for Mr. Albert and any member of his family. And I'm going to ask that that order, I should say a no contact order, direct or indirect. And I'm going to ask as well that the court order that Mr. Kearney remain away from the pizza shop, from the home of any of the Alberts, and from any place of work of the Alberts, and that he maintain a distance of at least 100 yards from those locations. The order in the Superior Court, I will say, is a little broader. The order entered the other day, and it now extends to all of the witnesses in this case, but since only only the Alberts are implicated in the case before Your Honor, I think it's proper to limit the order here to them.
In the motion to revoke?
Yes. With respect to the motion to revoke, Your Honor, I think it's important to consider that this is the same conduct, or another species of the same conduct, for which indictments are pending against the defendant in the Superior Court. There are indictments for intimidation of a witness with respect to Brian Albert, with respect to Christopher Albert, and with respect to Olin Albert. These indictments represent a series of conduct by Mr. Kearney, including showing up at selectmen's meetings where Chris Albert is a selectman. In one meeting, Chris Albert testified before the grand jury that at that meeting, Mr. Kearney came within 2 feet of his ear, holding negative signs about him, stuck his middle finger in his face, captured on camera for his viewers, and as he left the building, he and a mob of about 15 or 20 people pursued him to his car, screaming at him, calling him and his son a murderer. When Chris reached his car, Kearney and his followers surrounded it and prevented him from leaving until the police were able to back up the crowd. He's encouraged people to harass Mr. Albert at his business. He's run videos attacking members of the Albert family, including Mr. Albert's wife. I'll read you some of the titles of those, Your Honor, that were played for the grand jury. Episode 590, Call to Julie Albert. Julie Albert, I might add, has nothing to do with the Reed case, but in Mr. Kearney's view, she's a fair target because she's related to somebody who is. Therefore, to attack her is another way of putting pressure on and intimidating a witness. Episode 598, Life as Normal is Over. Time to hit the gas. No right for Chris Albert to live peacefully. Albert should be afraid. Kearney outside D&E Pizza. And those, Your Honor, were examples of some of Mr. Kearney's shows prior to the indictment. Indictment has not fazed him, Your Honor. He's continued to harass the Alberts and the other witnesses. When you look at the videos in this case, if you looked at them in isolation, if I looked at them in isolation as a prosecutor, I might think, oh, well, there's maybe a few sheets to the wind after his visit next door. He's clowning around. It's fairly innocuous, repulsive, but innocuous. But understandably, the Alberts and the Commonwealth look at them in the context of the prior conduct. His conduct has continued since his indictment, not only with respect to the Alberts, but as to the other witnesses. If Your Honor has viewed the exhibit submitted by Mr. Bradel, I had some discussion with him about what I would be asking for today. And I didn't indicate, quite candidly, that I was going to move to revoke Mr. Kearney's bail. That was not my original intention. But I did say, subject to, I don't recall the exact language, but Your Honor has it in front of him, subject to what may go on between now and then. Shortly thereafter, I discovered that Mr. Kearney had gone on one of his YouTube presentations and encouraged every resident of the town of Canton to file illegal wiretapping complaints against Mr. Albert. Now, I'd be the last person to say that citizens should not contact police departments if they think there's been a violation of the law. But one of Mr. Kearney's attorneys, Mr. Betterow, had already sent a letter, which I suggest was retaliatory in intent, to the Canton Police Department, claiming that Mr. Kearney was illegally wiretapped. Well, the Canton Police can do with that whatever the Canton Police are going to do with that. I think it would be improper for me as a person charged with prosecuting, as a special prosecutor charged with Mr. Kearney, to even express an opinion to the Canton Police Department. I have my own opinion of the merits of the complaint filed by Mr. Betterow. But that having been filed, Your Honor, what possible purpose does it serve for Mr. Kearney to encourage every citizen of the town of Canton to go and file complaints? And I suggest it serves no purpose but to harass Mr. Albert. I would also suggest that it is difficult to look at that video and think anything but that Mr. Kearney clearly saw the video camera, which was visible in the window, and wanted that video recording to be seen and, if possible, heard by Mr. Albert. I think one of the things that may be concluded by the Canton Police, and I don't want to get too far out in front of my skis, is that the illegal wiretapping statute requires that there be secretive video. And when a video camera is clearly visible in front of a store, I would suggest that's not secretive and therefore it's not illegal wiretapping. But if it is, I think when the Canton Police act against Mr. Albert, they can then do a survey of the whole town and possibly bring charges against everyone who has one of those doorbell videos. That said, Your Honor, it was still not my intention to move to revoke Mr. Kearney's bail. But then I became aware just a day or two ago, and I only became aware of this yesterday afternoon, Your Honor. Mr. Kearney, on his show, engaged in about a 10 or 15 minute vile attack on Elizabeth Proctor, describing graphically her giving oral sex to her husband and other such comments. Elizabeth Proctor has nothing to do with the Karen Reed case, except that she is the wife of a police officer involved in the investigation and a witness in the case, and therefore fair game for Mr. Kearney. And I mention this in particular, Your Honor, because one of the things that I understand the Commonwealth needs to show is that no order entered by the court is likely to be effective in eliminating the threat to the public, or in this case, the threat to witnesses in the Karen Reed case and in the Kearney case, and I would suggest the threat to the fair and objective administration of justice. I think that Mr. Kearney, by his conduct, has amply proved the court he is going to keep going with his intimidating conduct as long as he is free. And therefore, I ask the court to revoke his bail.
Attorney Braden.
Your Honor, Commonwealth uses the word retaliatory. This entire bait and switch the Commonwealth has perpetrated on me and Mr. Kearney is the only thing that's retaliatory here. On Friday, counsel emailed me with respect to the bail issue here today. I said to him that I had, at the time, 2 other cases today. I actually have 3 other cases today. But I don't have time on that date, meaning today, to do what we've been doing here for however long. That if we're going to have a quick bail hearing where the issue is how much money and stay-away orders that we've already agreed to in front of Judge Doolin in Superior Court, that's what I expected today. And I've never, in 32 years of practicing law, had a prosecutor or seen another prosecutor when I was a prosecutor say to me, yeah, come on in, we'll get this done quick, everything's going to be fine, and then come into court 5 minutes before coming before Your Honor and say, no, we're going to revoke his bail. Oh, really? Why? Because he said something nasty about somebody. And here's the kicker, Your Honor. In a private show that people have to pay to hear, not in public, to a private audience that somehow got leaked out to whomever. And that show was Thursday night before the Commonwealth committed to a normal bail hearing where there was a very minimal issue at stake. And now the Commonwealth wants to come in here on 5 minutes' notice to me and change it up because of this pretextual excuse about something he said that is non-criminal, non-actionable, that he doesn't like in a private setting. That's what's retaliatory, Your Honor.
Well, perhaps I can short-circuit all of this.
Please do. Thank you.
Wasn't this addressed in front of the Superior Court? This conduct was addressed?
It was, Your Honor.
So I think under my reading of the bail statute, Mass General Laws, Chapter 276, Section 58B, that the motion to revoke has to be brought at the first appearance in court. It doesn't say which court, his first appearance in court. If he got arrested in Chelsea, this hearing would be happening in Chelsea at the moment of his arrest. And so the idea that this was addressed in front of the court who's hearing the case on which the Commonwealth seeks to revoke, and there were conditions placed as opposed to bail being revoked at that point in time, I think was the first appearance, and I'm procedurally denying the motion to revoke bail because I don't think it's properly before this court.
Thank you, Your Honor. In that case, we would agree under Section 87, Your Honor, to the stay-away orders requested.
What about the cash bail request?
And Judge, in terms of a cash bail, Mr. Kearney's got no record. He's been to every court appearance. We talk, 10 times a week. He has 2 kids, lives in Holden. He's a former school teacher who has shows that he does every single night. I don't know of anybody who has more roots in here that's not going to cause any sort of a flight risk. So I would ask that you forego a cash bail, Your Honor. And he's absolutely willing to just make it a Section 87 agreed on bail condition relative to stay-away orders. And we ask that you allow that and allow him to appear on his personal recognizance.
So after hearing on bail, I'm going to release the defendant on personal recognizance with the following conditions: stay away, no contact, no abuse of the Alberts, remain 100 yards away from the pizza shop and any other workplace, stay 100 yards away from their residences. That's with the consent of the defendant?
Correct, Your Honor.
For pre-
May 15th, Your Honor.
That's fine. Oh, wait, was that one of the dates that was not a good date? Okay. May 15th is fine.
So you're going to be released with conditions for your parents back here May 15th for a pretrial hearing. Conditions are that you have no contact directly or indirectly with any of the Alberts and family members, that you remain 100 yards away from the pizza shop and any place of business in the home of the Alberts. Failing to comply with those conditions or picking up any new charges during the pendency of this case, you could be held up to 90 days without bail. That's your bail warning. You'll need to check in with probation. Before you leave the courthouse today, you'll need to sign those conditions of release. Commonwealth's motion to revoke your bail has been denied. The motion to dismiss has been denied. You're all set, sir.
Attorney Bradel, just to be perfectly clear for the record, the defendant consents to these conditions I've checked off under 87, that these are... Okay.
Thank you.
All right, thank you.
Thank you.
No, that's all we have.
Court, all right.
Yeah, no, yeah.